Hello, welcome to our annual observance of Constitution Day. Constitution Day is an unfunded mandate from the federal government. We're not supposed to like unfunded mandates. But I kind of like this one, especially when someone else offers to fund it. And let me start with a word of thanks to our sponsors today, the Office of the Provost, Dr. Sharpman, thank you so much, and the Jack Miller Center for the Study of America's Founding Principles, which also helped fund last year's Constitution Day event. We have today two speakers holding a conversation, not a debate, a conversation on religious freedom and equal protection after Masterpiece Cake Shop. Now, the speakers are going to go in one order. They're going in alphabetical order. Their last names both begin with W, but W-A and W-O. A little while ago, Jamie confessed to me that she was traumatized by alphabetism when she was in high school. So what I'm going to do is let them go in the original alphabetical order, Watson, Wadowski, but I'm going to introduce them in reverse alphabetical order. So our second guest, the first person to be introduced is Jamie Wadowski, Oglethorpe University class of 03. And I'll start by saying that Jamie is a Martian. Yes, you heard that right. She's from Mars, Pennsylvania. All joking aside, Jamie is an exemplary alumna whom we're glad to have back on campus for this program. Let me offer you a few details about her post-Oglethorpe and also her Oglethorpe accomplishments. I'll start with post and then go to Oglethorpe. Jamie is a lead human rights officer and EEO investigator for the D.C. Office of Human Rights, investigating claims of discrimination under the D.C. Human Rights Act and inquiries into discriminatory practices within the district. Jamie was instrumental in launching OHR's #Safe Bathrooms DC project, which enforces DC's regulation regarding public single-stall restrooms to be gender neutral. Jamie was part of a team that created the gay, lesbian, bisexual, and transgender GLBT cultural competency training currently required of all DC government employees, and assists the Mayor's Office of LGBT Affairs in conducting the trainings. Before joining the Office of Human Rights in 2011, Jamie served as a law clerk for the Senior Judges Chambers in the DC Superior Court. She said then she worked for 11 bosses.
Don't do that.
And completed a postgraduate fellowship at the Alliance of Justice, where she researched and drafted reports on the civil rights records of judicial nominees to the federal appellate bench, not including, I gather, Brett Kavanaugh. Jamie currently serves as a volunteer attorney at the Whitman Walker's Name and Gender Change Clinic, assisting transgender individuals in changing their name and gender markers and identity documents, and as a member of Berkeley Crescent Volunteers, volunteering for various LGBT organizations in D.C. She has served as a board member for the GLBT Attorneys of Washington Bar Association and as a student board member of the Georgia Stonewall Bar Association. In her spare time, she plays on soccer teams year-round, does yoga, travels around the world to film live music, takes care of her 2 feline fur children, visits her girlfriend in Denmark, and tries to learn Danish. Jamie graduated magna cum laude from the Georgia State University College of Law in 2007 and is barred in Georgia and D.C. She was a communications major here at Oglethorpe and was valedictorian of the class of 2003. She was also a JEO scholar here. Upon graduation, she was awarded the James Edward Oglethorpe Award, and in 2016 was honored with the Spirit of Oglethorpe Alumni Award. At OU, she was a 3-sport athlete, playing soccer in the fall, that was her main sport, basketball in the winter, and track in the spring. Here's what she told me about her athletic and other non-athletic accomplishments and accolades at Oglethorpe. Basketball, track, she was captain of the women's track team for 3 years. Main events, the 400 meters and 100-meter hurdles. Though she tried almost everything else too, including the pole vault. I think she topped out, she says, at 8 feet 6 inches.
It was new at the time.
Hey, I'm afraid of heights. So,
That wasn't nice. So.
Would have been for me. She also started and ran a woodwind ensemble and was senior class president, junior class president, and a senator her freshman and sophomore years. She was an ODK, Alpha Chi, Phi Eta Sigma, and of course, as she says, Chi Omega. And she was an Oglethorpe ambassador. So I don't think there's anything she didn't do at Oglethorpe. And we're very pleased to have her back to share her views today. And now let me go in reverse alphabetical order to Dr. Michael Watson. I know him less well, so I have less to say, but I'm extremely happy to have him here too. He is Associate Professor of Political Science at Calvin College in Grand Rapids, Michigan, where he's taught since 2015. Before that, he taught at Union University in Jackson, Tennessee. That was from 2007 to 2015, with a one-year sojourn as a William E. Simon Visiting Fellow in Religion and Public Life at Princeton. He's a native Californian. Does that mean that in and out is the best burger?
Of course.
Okay. Received his BA from UC Davis, an MA from Baylor in Church-State Relations, and another MA and PhD from Princeton. He is the co-author or co-editor of 2 books, one on C.S. Lewis, from which I've learned a great deal, and one on natural law and evangelical political thought, which I'm ashamed to say I haven't yet read. He's the author of at least 28 articles or book chapters, including one on Westworld, posted recently, which I highly recommend, and at least 20 book reviews. He is much in demand as a college lecturer, and my son assures me on the basis of time spent at a summer seminar at Princeton, a very good teacher. Please join me in welcoming both Dr. Watson and Ms. Wadowski to Oglethorpe.
Thank you, Joe, and I want to thank you and the provost and Oglethorpe for having us both here. I'm also glad for the chance to meet Jamie, and I'm doubly glad we're not debating after hearing that list of accolades. So, conversation partner comes much better off the tongue than debate. I'd also like to give a shout out to West Virginia Senator Robert Byrd today. For while I'm confident that Oglethorpe, and I hope my home institution, Calvin, would be willing to have an event like this just for the intrinsic value of talking about constitutional matters, other lesser institutions have needed the more utilitarian motivation provided by Senator Byrd's 2004 legislation, requiring that any school receiving federal funds must have an event this week, which has Constitution Day from Monday. So, before riding into the nitty-gritty details of cakes and writings and peyote and upholding building permits and things like that, I want to step back and look at things from a little further away on a more theory level. Talk a little bit about what constitutions do. You all have a constitution that was on your seat, a constitution that was designed that you could actually carry it around if you wanted to. Most constitutions made today are not so short that you can carry them around. Well, 3 things. Constitutions do a lot of things. I want to mention 3 things that constitutions do. First, they express the vision of what a political community aspires to. They reveal, whether they intend to or not, an underlying view of human nature. Whether by stating such aspirations overtly or reflecting political principles procedurally, constitutions by their nature affirm some ways of living together, and they close off or de-emphasize other ways. And they help us to manage the tensions that arise when our visions of the good life conflict. They are normative documents, and those normative commitments can be expressed in different and at times conflicting ways. Second, constitutions allocate power by authorizing various political entities at varying levels to exercise that power. Constitutions also limit power. They codify at the highest political level what government office or structure decides what, how that office is filled, how the relationships between different political actors are defined. Finally, somewhat paradoxically, constitutions are comprised of laws that create the mechanisms whereby we get more laws. Most constitutions delineate the means by which we work out regular politics from what we might think of as heightened or super politics. The former includes everyday legislation, how elections are conducted, or court jurisdictions drawn. The latter concern core principles and even changing the Constitution itself. Constitutions thus provide frameworks for doing the everyday business of politics, as well as what we might call the capital P politics, the super politics. The former works out the details of our political values and commitments. The latter involves substantively changing a commitment, or perhaps taking radical measures to protect a threatened value or principle, or coordinate 2 principles when they're intentional. And in our system, the Supreme Court, in making its decisions, often does both of these at the same time. giving us decisions that will affect policy at a regular level while also shifting our constitutional tradition at a super capital P politics level. One thing that makes our topic today so difficult and at the same time so important is the tension between two core American commitments, or at least how that tension has played out, particularly recently. Commitments enshrined in our Constitution: religious liberty for all and equal protection of the laws for all. This topic is controversial and fraught with tension politically and culturally, and for understandable reasons. The American religious landscape has changed significantly in the last few decades. Religion has always been contested terrain. It's one of those things you don't bring up at Thanksgiving dinner, right? But in the last few decades, what's changed about our wranglings about religion is the question of whether religion should remain as important and valuable in what seems to be an increasingly secular culture. And the changes in how we think about the guarantees of equal protection for gay and lesbian Americans has been, by any measure, a remarkable shift in the last few decades as well. One need only consider the laws that were at stake in Bowers v. Hardwick in 1986 and Lawrence v. Texas, laws at those times that could put people in jail for private consensual conduct. Compare that with the laws that are under consideration in cases like Masterpiece. Laws that can fine people and their businesses, not yet put them in jail, perhaps, but for stigmatizing gay and lesbian people by refusing, in this case, to service wedding ceremonies. That's a remarkable shift. It's no wonder that as a society we're trying to figure out how to work with those changes. It's not surprising that we've had growing pains. Religion and sexual identity also go to the core of who we understand ourselves to be. These are not just abstract constitutional debates. The outcomes matter a great deal because they impact the lives of real people at the core of real identities. So what do religious liberty and equal protection look like after Masterpiece? In my time this afternoon, I'll say a few words organized around three different questions. I recognize it's kind of a trick because I'm answering the questions that I'm asking myself. But the three questions are this: what are the takeaways from Masterpiece? What will happen next? And what do I hope will happen next? Which is more musings than any sort of hardcore laid out white paper sort of argument. So, what are the core takeaways from the Masterpiece case? One of the takeaways is the framing that Justice Kennedy's opinion gives us. He juxtaposes these two important principles that I've mentioned before: the authority of the state to protect the rights and dignity of gay persons who wish to marry and seek goods and services. In this case, a way of talking about equal protection with public accommodations law, right? As well as the principle of the right of all to free exercise for the First Amendment rights of free speech and free exercise of religion. Was Jack Phillips is the baker in Masterpiece, was his refusal to bake a wedding cake for Charlie Craig and Dave Mullins in 2012 a violation of their right not to be discriminated against based on their sexual orientation, a right articulated by Colorado's Anti-Discrimination Act? Or was Phillips exercising his right to free speech by declining to communicate a particular idea, and his right to free exercise by not participating in a religious ritual he believed to be contrary to God's will? And the answer to that question is not found in the opinion. Some have called this a punt. 7 justices ruled in favor of Phillips because, not because they agreed on how to characterize Phillips' refusal to bake the cake, but because Colorado's process was not conducted with neutrality towards Phillips' religious beliefs. In fact, 7 justices agreed that Colorado showed hostility to religion, and based on prior cases, that this would be a problem. And one case in particular, one of my favorite cases to try and pronounce, which is the Church of Lakuni Babalu I versus the city of Hialeah, which involved a group of folks who practiced the Santiago religion. And as part of that, their religious rituals involved sacrificing chickens. The city of Hialeah did not like that for a number of reasons and created a legislation to more or less outlaw, an ordinance to more or less outlaw that. But did so, it became clear that they did so targeting the Santiago religions. It was directed at their practice rather than a general law, neutral law of general applicability. One commissioner compared Phillips' invocation of his religious beliefs to religious defenses of slavery and the Holocaust. His His religious defense was described as despicable. The takeaway here is because there was overt hostility towards Phillips' religious beliefs, the court didn't address the underlying substantive issue, admitting that this would need to come in a later case. And this is really the perfect send-off for Justice Kennedy. You know about Justice Kennedy, he's that hinge vote in the middle, which means he disappoints both sides all the time. And that's what he did right before retiring from this case. So that's why some people call this case a punt. But I would suggest there's still some important things that come out. One of these things is that the court repeated something that it said before, which is that reasonable people of goodwill can believe in the traditional view about marriage, or can believe in traditional sexual mores. Kennedy's opinion in Masterpiece echoes what he said in the Oglethorpe, which is that this view, traditional views about marriage, long has been held and continues to be held in good faith by reasonable and sincere people here and throughout the world. This is an important point because it takes on a contested issue culturally, which is whether traditionalists like Jack Phillips and others are akin to racial segregationists and bigots. If they are, then of course it would make sense for law and policy to treat them as such. Some progressive scholars like Mark Tushnet have openly called for those who have opposed same-sex marriage to be treated as if they were neo-Confederates or Nazis, a description that would have to be applied not only to white evangelical conservatives, but Orthodox Jews, Mormons, most American Muslims, and the majority of about 6% of the United States population who are African American and Protestant Christians. So the court's position was that this is not like the case of Bob Jones in 1983. Bob Jones in 1983, the court ruled that it could lose its tax exempt status, and it did, because of a noxious racist policy banning interracial dating. The court did not say then, and we would never want to say, that the noxious racial views expressed by Bob Jones then were held in, quote, good faith by reasonable people here and throughout the world. We would hopefully never think that someone would say that about noxious racist views, that in the case where that's going on, that there are good people. And I thought that was uncontroversial, and remembered that actually a rather high-ranking American official said that there were fine people on both sides of just that sort of issue in Charlottesville maybe a half ago. So not as rare as it should be, but still notable that the court did not take that position. The takeaway here is the court's position that belief in traditional sexual mores is not necessarily the same thing as an animus towards a group of people. The other takeaway from Masterpiece is a more technical one. The Church of the Lukumi Babalo I case established that hostility towards religion could sink legislation that burdened religious exercise, and the Colorado Commission's record established that hostility. For legislation that burdens religious free exercise to pass constitutional muster, it must be, from an earlier case, the Smith case in 1990, and affirmed in a case in Texas in Bernie 1997, the law must be a neutral rule or neutral law of general applicability. It means it can't be targeting a particular religion. So if, in the case of Bernie, you had a church that wanted to expand its sanctuary, but there was a general law that said that we have a historic town, and in order to change your historic building, you have to get the town's permission. That's not targeting the Catholic Church that wanted to change it. That would apply to any building or any business that was on their little historic downtown. So the standard was that the law can't target religion or be hostile towards religion. So at the very least, that means no hostility. And by that measure, the city of Hialeah failed in 1993, and 7 justices agreed that the Colorado Commission failed in its treatment of Jack Phillips in Masterpiece. But there's neutrality as understood in how a statute is created, and there's also neutrality in how the statute is applied. That is, whatever rule is enacted to protect people from unjust discrimination, is that rule applied generally and neutrally? Or is it applied to some groups in some situations and not others? It's the second consideration of application that is a novel contribution of Masterpiece, and explains the back and forth we've read in the decision. It's riveting. I recommend it. Go out after this talk and you can read the back. It was actually not bad for a constitutional opinion, I think. I like reading them, though, just for a living in some sense, so I'm a bit of a nerd that way. There's this back and forth between Justice Kagan and Justice Gorsuch about what constitutes expression and meaning, and whether a cake is always just a wedding cake, or whether a cake can actually, in a weird way, be sort of a straight wedding cake or a gay wedding cake, depending on what sort of ceremony it's being used for. Sorry. This is because the court mentions not only the Colorado Commission's hearing of Jack Phillips' case in Masterpiece, but 3 other cases in which different cake shops turned down requests for what were deemed anti-gay cakes with messages about traditional marriage. The argument between Gorsuch and Kagan was over whether the same standard is applied to Jack Phillips, a conservative Christian asked by a gay couple to make a wedding cake for their ceremony, comparing that to 3 other cake shop owners approached by a religious conservative with a religious conservative message wanting to be put on those cakes. I won't go into the details of the back and forth. We can talk about that later if you like. I just want to highlight the importance of the holding in the court, and that the court looked at that issue. Kagan says that it's not, doesn't matter. Gorsuch would say that it does, but that they're even considering the neutrality of the application is a strengthening of the standard from what it was in ILA. It's not just can you find out what was said when the law was passed. Is it applied differently? Because not only is sexual orientation protected by Colorado's law and other anti-discrimination laws, but so is religious identity and other identities that we have. All right. So that's what I would sum up as some of the takeaways of the case. Now, what do I think will happen next? Well, I learned in the election of 2016 not to say much about what I think is going to happen next, as did many of my fellow political scientists. So this will be a very short section. And I actually don't know what happened today. Today was the day they were going to vote. They were going to vote on whether or not to put the nomination forward, but I think it's been delayed. We don't know. Okay, so I'm not sure what will happen with the Kavanaugh nomination. And the less I have to say about that, probably the better. It strikes me as an incredibly difficult sort of situation. If somehow he makes it through, I will say, I think Chief Justice Roberts becomes the Kennedy hinge person. He will be the one that occupies that seat, or who's going to decide whether it's going to be 5-4 one way or the other. If you're on the progressive side, that of course isn't great news. That's going to make the court more conservative, though I have some qualms about calling the court liberal and conservative in some ways. At the same time, as we saw in Chief Justice Roberts' treatment of the Obamacare case, he's something of an incrementalist. So I don't think that you're going to get the handmaid's tale tomorrow. If that ends, I think it'll be a more conservative court, but I think it'll be an incrementally more conservative court. But it may be that we don't get Justice Kavanaugh. We may get a delay, and then we may get the prospects of a Democratic Senate in November, who may then decide to pull or reverse Merrick Garland and see how long they can delay hearing whoever the next candidate would be. And we won't get anything until after. I don't know. In other words, this is a lot of speculation about what is actually going to happen. We do know, I think, that the issue is not going away. There are other cases pending on this particular sort of wedding cases. Jack Phillips has already been cited in another instance in which he has refused to make a cake. He was called on the very day the Supreme Court agreed to hear this case and asked to make a case by a transgender woman celebrating her transition, and declined to do that, and it has been cited by the same commission that was involved in the Masterpiece case. So there will be other cases that will bubble up, whether that one gets to the Supreme Court or not, or something else will. So we know this issue isn't going away, even though we may not know what exactly is going to happen. I'd also say we know that religious liberty issues, equal protection issues, aren't just about wedding cakes and aren't just about this particular issue. There are many other cases that may make their way to the Supreme Court. There's a church in San Diego that California is requiring to cover abortions in their health insurance policy for their employees, and they're pursuing about that. In D.C., the Catholic Church is involved with the Metro's policy on what they can advertise in the Metro, whether or not it's offensive or not, different things. So there's going to be other things as well. And I'm not terribly prophetic about how that's going to go. So in my closing section here, what I hope will happen on some of these things, and again, this is my more like a musing and not anything like happy to talk more about details, but I have not written out a policy paper or anything. The first thing I would hope is that religious liberty would be understood much more broadly and more accurately than it is in many quarters. And I will start with my own quarter. I come from an evangelical Christian background. I hope at some point that the tribe that I grew up with will recognize that if religious validity, or if religious liberty has validity at all, it has validity for all. Some of you may have heard about the protests about a Muslim mosque being constructed in Murfreesboro, Tennessee. The opposition to that was led by mainly Tennessee Baptists, right? And Christians should support free exercise of their fellow Americans who are Muslims, trying to build mosques, other religious minorities. Religious liberty cannot just be a parochial privilege for those who see themselves as having perhaps the true religion. To organize legally and politically to oppose others exercising their God-given right to religion, I suggest, is not only un-American, but ultimately un-Christian. The other thing that I would want to talk about a little bit is the idea that protecting religious free exercise means giving people a get-out-of-the-law-free card. The laws that we have on the books require there to be sort of conversation, a weighing. It requires that religious liberty be something that has to be taken into account. It does not guarantee a win. It is never designed to do that, and it hasn't been that in practice. We've had RFRA laws on the books for over 25 years. The first RFRA law was joined by everybody. Americans United for the Separation of Church and State, the ACLU, as well as folks like James Dobson on the right. And that was in response to a Supreme Court case that almost everybody disliked. If RFRA laws were going to lead to a parade of horrible, with all these awful things happening, we see more examples of that. And I don't think that we have, but that might be a contested supposition. I'd also like to see religion recognized as more than just what we see in the high-profile cases, the Kim Davis, the Jack Phillips, the white evangelical folks, right? You think about religion in the United States, it's much deeper and broader than just what has been the most high-profile cases. The fastest-growing religion in the world is, you would know?
Islam.
Islam is correct, okay? And the American Muslim population is going to be doubling by 2015. Muslims have very strong views about certain things with diet, certain things about dress, moral views. This is not just a white Christian issue. It's also important to recognize that RFRA laws and religious liberty laws have protected religious minorities for quite some time. There's a 2014 Fifth Circuit case called McAllen Grace Brethren versus Salazar. This was a situation in which a federal agent trying to investigate a violation of the Bald and Golden Eagle Protection Act covertly infiltrated a Native American religious ceremony, saw they were using bald eagle feathers, stopped the ceremony, confiscated the feathers, told them they needed to sign a relinquishing of the feathers or they'd be criminally prosecuted. It was a RFRA type law that allowed those Native Americans to have a stronger day in court. So even if you don't think that a RFRA or religious liberty value would win Jack Phillips today, I hope that you will still see that there's value in these types of considerations, these types of laws. The other thing I'll say, and this is just about, in some ways, sometimes I hear this debate talked about as if there is this category of gay and lesbian Americans, and then there's a category of religious Americans, as if there aren't religious gays and lesbians, and if there aren't, and if religious Americans are all on one side on these issues, right? There may very well be religious Americans wanting to exercise their right to support a progressive moral issue, right? It's not always going to be the way that it is portrayed right now. We have done this throughout American history, finding ways to soften the hard edges of policy, right? To allow people to exercise their religion or exercise their free speech by having, whether you call them exemptions or other ways of making things work. We've not required Quakers to fight in the military. We've not required Jehovah's Witnesses to salute the flag. When Prohibition happened, Catholics and Episcopalians were able to have wine with their communion. In prisons, Muslims and other people with dietary restrictions were able to have those. This is something that we've done, and I would hope that this is something we continue to think about how we do it. I agree with same-sex marriage advocate John Corvino, brilliant law professor, and traditional marriage defenders Ryan Anderson and Sharif Gerges, that wrote a book together. They argue that religious liberty shouldn't just be thought of as religious, that secular people too have core convictions that should be able to have their day in court. And we actually have a history of this when it comes to military conscientious exemption laws. So we have a couple of cases where we have someone who had a very strong conviction about violence, and we were able to recognize that that should be respected in law. How all that works out is a tricky business, but law the Constitution and practices like this are tricky businesses. Secular Americans have conscience concerns and convictions as well. Let me close by talking a little bit. I'm about time to close, right? Yeah. A definite yes. Okay. Yeah. Pluralism and the price of living in a free society means living with people you disagree with, even people who offend you deeply. And I recognize it's controversial for me to say this, okay? I've never been a religious, racial, or sexual minority. So in some ways it's easy for me to say, and I realize that. I don't know what it's like to be in those positions. But I look and see that there are still lots and lots of people that have core identities that conflict on these different issues. And these people aren't going to go anywhere. We're going to have to figure out a way to live together. I don't think that those who hold traditional religious views are akin to skinheads or Nazis. So I would encourage us to think, how high a bar do we need before we invoke the coercive power of the state to fine people tens or hundreds of thousands of dollars and effectively drive them out of the public square? I'm a political theorist. I love Jean-Jacques Rousseau. I love him. I love studying him. He said in writing his constitutions that you cannot live in peace with a neighbor you believe to be damned. And that's why he wanted to have one civil religion to outlaw Christianity. The great American philosopher John Rawls says the American experiment in ordered liberty and religious liberty has proven Rousseau wrong. It's done so because we've found ways to live together, soften the edges of these conflict areas. I would hope that we can find a way to respect the rights and dignity of gay and lesbian Americans while also finding ways, within reason, to accommodate the religious scruples of more traditional religious Americans and all Americans who may have religious or secular convictions that are close to their hearts. Thank you.
All right. Hello, everybody. I was going to say you're saying you're nervous to speak. I'm not actually a lecturer, so after listening to your bio as your professor and speaker and everything, so that is not a background that I have. I actually took public speaking when I was here at Oglethorpe, but that was about 15 years ago, and I'm really glad that my professor from the time is not here to judge me on this. I wanted to come to kind of speak about what I know, and looking back at how I prepared for those speeches, and I spent a lot of time walking out in the woods and trying to memorize what I was saying. So not going to do that here. So I just wanted to start with actually a quote from the Georgia Supreme Court. And this might not be a quote that you all have heard of before, but the Supreme Court in that case said, no laws create moral or social equality between the different races or citizens of the state. Such equality does not in fact exist and never can. The God of nature made it otherwise, and no human law can produce it, and no human tribunal can enforce it. So this was said by the Supreme Court of Georgia in 1869. Another case that was from my home state of Pennsylvania, where there is a town called Mars, and we have a spaceship, so if you ever want to come visit it, it's pretty fun. You can sit on it and everything. But a quote from the Pennsylvania court was, segregation of the races is not prejudice or injustice of any kind, but simply to suffer men to follow the law of the races established by the Creator himself, and not to compel them to intermix, contrary to their instincts. So this was said by the Pennsylvania court in 1867. So we fast forward about 100 years, and we kind of move up to, we have the mid-1960s, and at the time, a very heated debate that's happening within this country is the question of segregation and integration, as well as whether laws that are banning interracial marriage are legal. And when I was actually a student here at Oglethorpe, I decided to try to write my senior thesis comparing the rhetoric that was used at the time that these laws were being debated in courts across the country, whether they were called anti-miscegenation laws, whether those laws were valid or not. And I wanted to compare the language that was used at the time, not just religious language, but language in general that was used by people to oppose interracial marriage, And I wanted to compare this to the language that was being used at the time I was at Oglethorpe to oppose same-sex marriage at the time. So I was writing this in 2001, 2002. You couldn't yet get married anywhere in the country, not even Massachusetts or Vermont. I had not yet been to law school, so I had no idea what I was doing. I was like Googling cases on the internet and trying to figure this out. But in writing this, I was a communications major at the time, and so that was why I was focusing on the rhetoric. I wanted to go to law school, and so I was trying to kind of learn some of the background around this. And this quote stuck with me when I was writing that, and don't know if y'all know what this one is from. But in that case, the trial judge said, Almighty God created the races, white, black, yellow, Malay, and red, and he placed them on separate continents. The fact that he separated the races shows that he did not intend for the races to mix. Has anyone heard that quote before? No. That was the trial court in Loving versus Virginia. And that case, actually at the time, had sentenced a couple that had gotten married in D.C., in Washington, D.C., where it was legal for them to get married. They moved back to Virginia, and they've been sentenced to a year in prison for getting married. And their sentence was suspended for 25 years. They would never serve a jail sentence if they left Virginia and did not come back for 25 years. So in this era of these things happening, these cases going through the courts at the time, and we look at from cases from the 1800s all the way up through the 1900s here, the things that happened to change the course of history around that time, a big part of that was the Civil Rights Act that happened in 1964 as a result of the civil rights movements of the 60s. And this law was put in place because the country decided that as a whole it was a value to treat citizens equally and to allow people equal opportunity in employment, in accessing public accommodations, in schools, in housing. And these laws were not very popular at the time they were enacted. And as we've kind of talked about a little bit, they were justified by many things, including often religious reasons. At this time now, it's really hard to imagine that anyone could deny service perhaps to someone based on their race and have that be upheld based on religious reasons. Like, we've accepted as a society that that's not okay. That's not a valid reason. And part of the reason why that's happened has been the enactment of laws such as the Civil Rights Act of 1964. And what came from that at the time also included the D.C. Human Rights Act of 1977. So I live in Washington, D.C. now. I work for the D.C. Office of Human Rights, and we are a D.C. government entity that enforces the districts. We think of ourselves as a state, even though no one wants us to be one. We enforce the city's Human Rights Act. And so my role is to investigate complaints of discrimination, mostly in employment, also in housing, public accommodations, and also in schools. So this was not something I knew existed whenever I was a student here, or even when I was in law school. I never had heard about, I didn't know anything about administrative agencies. I didn't know anything about them until I started my job there, and I still didn't really know much about them until several, months into the job. But it was a way for, governments to establish a body that was an expert in a particular area of the law, and to give people an alternative to going to court that might be faster, might be cheaper. In our case, it's a confidential process, so if people have interest in not being a public record like the court, then they can come to us, and that stays as a private kind of procedure all the way up to the end of if we make a finding of cause to believe that discrimination occurred in that case. At that point, it would become a public hearing, or if someone appeals it to the courts. So what we look at in the cases that I investigate, we look at general public accommodations laws that are such as the ones included in the Civil Rights Act and included in the D.C. Human Rights Act. And the D.C. Human Rights Act, we really like to brag, is probably the most expansive civil rights act in the country. So we have 20 protected categories. So most people are familiar with, race, sex, age, religion. Ours goes farther and articulates sexual orientation, gender identity and expression, even things such as personal appearance, which is, height, weight. We go on to, like almost nowhere else, political affiliation. So that would be special to DC, of course. And so we look at all these classes, and if we have a case where someone says they were denied services, we look at three things. And first we look at whether someone is a member of a protected class. And this is often pretty satisfied because everyone has a race, everyone has a sexual orientation. So that one is usually pretty easily accomplished. Second, we look at whether someone sought access to services that are being offered to the public in a typical manner. So public accommodations are hotels, taxis, restaurants, things that are generally open to the public. And then we look at, did they not receive the services, or did they receive them in a markedly hostile manner that a reasonable person would find to be offensive? And so we're looking at this situation in Masterpiece Cake Shop. And it's interesting because I've talked to so many people and so few people have read the decision. So there's a lot going on about like what the actual facts were. In this case, a gay couple, two men, one of them had his mom with him. They went into the cake shop and they said they wanted a cake for their wedding. Before there was any further discussion about what kind of cake they wanted or what they wanted on the cake, the cake shop owner said that he would not make a cake for a gay couple's wedding. And so that was a brief interaction. That after that, the couple went and filed with the Colorado Commission on Human Rights. I think it was the Human Rights Division, which is similar to my office and what we do. And so it's fascinating to me now that I work in like the administrative realm, but I'm sure it's not quite as exciting to all of you. But that was where this case came from. And someone like me investigated that complaint and looked at those elements similar to those, and they said these people were part of protected class, sexual orientation. They sought a service that this person offered to the general public, a wedding cake, and they did not receive that service. And then in our cases, we look at did the other party, the business, did they have a legitimate and non-discriminatory reason for not offering the service? And in this case, the commission, first the division, and then the commission found that the person, that there hadn't been, and I think we look at also whether it is a business necessity. And so we've had cases where they have to argue that it's a business necessity and that's why they're enforcing that kind of law. And so kind of when Dr. Knippenberg asked me to talk about this, I was thinking about how this case would be handled by our office if we got something like this. And DC is a fairly liberal jurisdiction. In the 8 years that I've worked in the office, I don't think that we actually have had any cases that had raised this specific issue. So I didn't know. I was very interested to kind of look into this more. Some of the things that I thought about were that there have already been considerations for religious exemptions. And those exemptions are built into the Civil Rights Act and also into the Colorado Human Rights Statute issued here. They say that these things don't apply to religious organizations such as churches. And so in that case, they can choose to hire someone that is the same religion as the church, for example. So they've considered this and narrowly limited to people, organizations, businesses that are religious in nature, such as the church. They didn't consider kind of this broader possibility that an individual business owner could decide what he would or wouldn't offer to someone based on his own religion. And as I've talked about kind of earlier, we've kind of already been through this before. This question was addressed in the context of race from the 1800s up through the 1900s, even in the context of public accommodations. There was a case almost exactly, well, not almost exactly, but very similar to this one, where there were three African-American individuals that had sought services from someone who he did barbecue, was what he considered his art at the time. And he said that he objected to contributing to any way that the races would mix because he found that to be against his religious beliefs at the time. And the Supreme Court in that case held that the state had a compelling interest in ensuring equal access to services for all people, and that wasn't a sufficient justification for denying services. There's not too much that distinguishes this current case from those cases then. If you look at Masterpiece Cake Shop and you think about the gay couple and you replace it with almost any other protected class, the example becomes kind of ludicrous. You know, you have an interracial couple that walks in and they would like a cake. And he says, no, I object to interracial marriage still based on my religion. We would, as a society, accept that that's not okay. If a Jewish couple walked in and he said, I believe that Jews do not accept Jesus Christ as Lord and Savior, so I can't sanction, your wedding either. That would be allowed under this exemption. It could be applied so broadly that the statute itself would kind of lose all power. There would be just kind of many different instances where someone could raise a religious objection. And as they would say in law school, like the exception kind of swallows the rule. The rule kind of loses the ability to do what it was intended to do, which was to ensure dignity and equal access for people. So some of the other main thoughts that I had when I kind of looked at this, and to practice for this, I decided to try arguing with people on Facebook about this topic. That's a super great way to hone your skills and talk to reasonable people that are well informed about the topic. But brought up some good things for me to think about. And one of the issues that was already mentioned was kind of the idea that there were these other bakeries that they had been asked to make cakes with anti-gay religious messages on them. And the main distinction, which is addressed by Justice Ginsburg in her dissent, is that this is a business that makes wedding cakes. A gay couple went in and they wanted a wedding cake, and they were told no based on who they were. And the product in that case is the same, a wedding cake, and that will be offered to a straight couple, but not to a gay couple. So whether the person receives service depends on who they are. Now, if the product changes, and it is something that business is not offered to anyone, then it's not a matter of who they're serving, it's a matter of what they're serving. So if you have, a halal shop that doesn't serve, pig products, for instance, it's not that they're discriminating against the people that come in because they don't serve those products to anyone at all. And then another thing would also be, people brought up, well, what if someone wanted a cake with like a swastika on it? What would you do then? Well, the first thing we look at is this person a member of a protected class? If you look at race, sexual orientation, age, in most statutes, being a Nazi or a member of a Nazi party is not a protected class. I would wonder how that would go in DC because we do protect political affiliation. I'd be kind of interested to see how that might play out. I don't encourage anyone to try it just to see, but so the first thing I would look at is just to kind of bring back to these main elements that we look at. What is this person a protected category, and is their membership in that protected class the reason why they were denied this specific service? So I think just generally some of the things I saw online when this whole debate was going, I saw this great quote where someone was referencing the civil rights laws and how they came to be, and they said, it wasn't about the bus seat, it wasn't about the restaurants, it isn't about the cake now. It's about the principle of full and equal access for all citizens to receive things without hostility, to go out into the public marketplace and not have to fear how they're going to be treated, or whether they might be out shopping for their wedding with their mom, and then have someone they come up against say, we don't serve your kind here, and we can't give you that. Even though we would give it to other people, we won't give that to you. So, working for the Office of Human Rights, we try to work for our mission to eradicate discrimination and make sure that people are treated fairly. And I think that in this particular case, we would have gone along with the Colorado Commission on Civil Rights and how they ruled in this particular case. As was mentioned, the ruling of the Supreme Court was relatively narrow. They didn't actually address this main question. And what they looked at was just how the courts in reviewing how the Colorado Human Rights Commission addressed this issue when they were reviewing it. And they determined that remarks that were made by one of the commissioners were hostile and showed hostility towards religion. And so they kind of, I think, punted the particular issue and did not deal with that particular question. And it, I think, also surely will be back up again. And many cases are already working their way up through the courts all over the country. But I would kind of imagine a world where someone could still deny an interracial couple a wedding cake, and that does not seem like it would be the kind of society that I would want to live in, or that most people in this country would want to live in. So, thank you all very much.
Both Ms. Wadowski and Dr. Watson have agreed to answer any questions you all might have. So please have at them. If not, I'll start with questions gently. But I'm perfectly willing to let you all start. If not, I've got questions I can ask. Eli.
I have a question with the DC process versus Colorado.
Sure.
Since so much of the case was on how Colorado, the commission, looked at it and evaluated it, do you all consider that when you're evaluating, cases in DC? That, I mean, I guess it's open to the public and all of your notes, things become part of the record. What's that process like?
Yeah, I mean, we try to treat every case that we deal with fairly, and I think that this whole case has, made us more conscious of how we deal with people. We already try to work in a fair and neutral manner. We don't really have any interest, in which party coming through the door, is going to win. We serve the law, and that's all that we, try to look towards. But I do think it makes us conscious that what we write, and it does become a public record that's subject to FOIA in that case. So it hasn't really changed the way we've done things as of yet. I think we operate as we think of ourselves as a tiny little agency in the corner of the universe, and we would never expect our case to end up in front of the Supreme Court. So I've got to wonder what it was like to go through that experience of having that person's investigation and the case work before at the Supreme Court.
Glenn?
Thank you both, Jamie and Michael, for making Robert Byrd proud. I hope this is the kind of thing that we should be doing on Constitution Day. So you both prompted me to think about a lot of things, but Michael, correct me if I'm wrong, you're a professor at Calvin College, right? And Calvin has a faith statement, correct? So that in order to work at Calvin College, you have to believe in and practice certain traditions of the Reformed Church, which seems to be fine, being a private institution, and that's
Good.
So it would be wrong, of course. You could not discriminate based on race at Calvin College. You couldn't say you couldn't get in or work here because you are of a certain race. You could, however, say that if I didn't subscribe to the principles which your school does. And so I'm thinking about the gay marriage, and whether it matters to you or to evangelicals in general, whether you think that this is a choice or it's not a choice. You could let a choice be black, white, or...
Sure.
But if one believes that this is a choice, you've chosen to be gay, and therefore we don't accept that because it says in our interpretation of the Bible that that's wrong. Or if it's not a choice, and then doesn't that become something different?
Well, gosh, I'm on camera here speaking on behalf of my college. So I'll distance myself a little bit. The position of the religious denomination that governs Calvin College is that there is a distinction between orientation and behavior, and that gay and lesbian people are made in the image of God. They are people for whom Christ died. They are worthy of respect. We have a pretty robust gay and lesbian student group at Calvin. And so no, we would not, either in hiring or in our students, discriminate or keep, now it depends on what people think of as discrimination. Calvin also does hold to the historic traditional Christian view about sexuality, right? So in terms of behavior, faculty are expected either to be single or to be, if they're married, to be married in a heterosexual marriage. But that issue actually is very much a live issue. California dealt with this last year with regards to the transgender issue, and California, there was a bill that might take away funding for any colleges that didn't agree with California's definition of what, which as we know, colleges are on the margin for funding, and to reach, that would basically shut down a number of religious colleges. There was a campaign, and so it's not so much that we might be hit by law as much as we might have designations taken away if it got to the point where belief in traditional views about sexuality were akin to race, to racial animus. If that's the case, then Christian colleges like Calvin will have a very tough decision to make.
One of the things I think is really interesting, and actually I took First Amendment law in law school, and I was really excited. I thought, that was a class I really looked forward to taking. It actually ended up hurting my brain every day, and was one of not the most miserable classes I took, but along those lines, and the fact that it's hard and complicated, it doesn't make a lot of sense. And one of the things that you kind of brought up was this concept of it's basically called like a mutable or immutable characteristic. And something like race is considered an immutable characteristic, it's unchangeable. And there's been a lot of debate, whether sexual orientation is or isn't an immutable characteristic, and there's so much debate on that, I'm sure you're all aware. But one thing I think is interesting is that something that is a mutable, changeable characteristic is religion. And so people change their religion all the time. I was raised in Catholic school and consider myself nothing right now. So I think that's kind of an interesting way to look at it, because no one thinks of that side of the argument as why is religion afforded kind of this protection when it is something that's easily changed.
Kaylee, and then Dr. Wise.
So two of the big issues that were brought up by Jack Phillips were that his freedom of religion and his freedom of speech were being infringed upon. We talked a lot about religion, and I was curious what your thoughts were on the free speech argument, and whether or not a wedding cake or making a wedding cake designates support for that wedding, or what your thoughts were.
Sure, and I think that's kind of another question that the court really didn't totally address, but one of the things that was kind of raised is, and again, this is part of why First Amendment law hurt my head a lot, and it's like, what is considered speech? And one of the things that I think Justice Ginsburg talked about in the dissent too was the fact that to be considered speech, it needs to be recognized by the person receiving the message as a message. And would anyone look at a cake and think there was a message? And that message was coming from the person that made the cake. And that is maybe a bit unclear and kind of a harder line to draw.
Yeah, so free speech is the one that did not get addressed very much. And it's interesting, in Ginsburg's dissent, she actually does say that it's not a cake for a same-sex wedding or a straight wedding, but she did say it's their wedding. So this is where the debate comes around. Is what he was up to, if from my own point of view, if he just had a bunch of wedding cakes in the fridge, then I would agree that it would be discrimination if the gay couple wants to grab it and take it out. But from where he's coming from, the process by which he makes the cake is very involved. This is actually kind of backed up by what people do, and they actually go and they want to visit with the baker, they want to talk about what their vision is, and he talks to them. That's where he comes from. My objection is I'm now involved in a religious ceremony that I have a problem with. And this is where we differ a little bit as to characterizing what happened, because if he had an objection to serving gay and lesbians, he wouldn't serve gay and lesbians. But he offered to make them other things, and he had made gay and lesbians other things. So it wasn't like gays and lesbians not welcome here, was you're welcome here, I just don't feel like I can do this particular thing. And that's the decision we have to have. Are we thinking that we would want to make that happen on that particular sort of event, a same-sex wedding in this case. The free speech thing is really interesting because if what does the work in overcoming the religious scruples of people like Jack Phillips is the dignitary harm, and that's a real thing. I'm not dismissing that. And again, like I said, I don't know what that's like to feel that where I'm going, but that's a really. But if that's what does the work, then on free speech, it's also going to really change free speech, and would have to reverse Supreme Court. I mean, the Supreme Court has defended much more harmful things that have been said, in my opinion. So the horrible Westboro Baptist Church, they want the right to keep saying horrible things. The Boy Scouts v. Dale, this guy who was a Boy Scout his whole life, a gay scout, and was not allowed to continue. Like that strikes me as a harder thing than as hard as it would be to have a bad day with the cake and feel like you've been demeaned. On free speech, it's much more hardcore, and the demeaning aspect of that is a bedrock constitutional principle. So that's why, from where I'm going, the dignitary harm aspect of it has to be a player, it has to be considered. But if it can override religious scruples almost every time, it's also going to, by the same logic, override free speech, it seems to me. I don't know how you do one without the other. So Clarence Thomas addressed this, but you're right, no one else really addressed this issue. Does what he was doing, when we think of, when you think of a wedding cake, it doesn't have a message to it, and then it can have a message going to either a straight or a gay wedding cake. The Supreme Court has said that nude dancing counts as expression. Okay, in Glendale Theater, I don't know, remember the case, burning a flag, right? So there are lots of examples of things, hanging an American flag upside down, wearing a black armband. There are a number of things that the Supreme Court has said, those count as speech, and the bar is pretty high on being able to say, no, you can't do that. So in that sense, the speech and the free exercise are together. So I think we both agree that as it moves forward, those are going to be pretty key factors in figuring out how to balance these important things.
I was just, in this whole thing, it sort of surprised me that the ritualization of wedding cake as opposed to cake, just if you think in terms of service, and selling somebody something else, but you call it a wedding cake, and all of a sudden you're involved with it in a different way. So I was just thinking, what if this couple goes to a car dealer and explains, we're a gay couple, we're about to get married, and this car is for our honeymoon.
Yeah.
Does the car dealer get to say, oh, well, we don't sell cars to gay honeymoons?
Mm-hmm. Right.
So I just, and I guess I was thinking about with Charlottesville rather, what if the guy who ran over the demonstrator goes to buy the car and says, I'm on the way to this demonstration, and boy, am I ready to, if they do anything, I want a car that's going to do something,
Yeah.
Do I say, oh, well, I don't sell cars to people like you?
Yeah. So if what religious liberty means is a get out of any responsibility card, then that's a very salient point. Like if I were to say, I get to speed, officer, because I'm late for church, right? That gets me out of this general law, but that's not how any of these RFRA laws are designed, right? So there are ways of testing whether someone has a sincere religious belief, right? So think about the Native American. There's a case of a Native American boy. The school had a policy: your hair had to be cut a certain way. He had his hair long for religious purposes. That's what the court has the tools to be able to say that's a reasonable place where maybe we can find another way of keeping the law but finding an exemption for this boy. What you're talking about would be chaos. I don't know any religious liberty advocates who would want to give religious liberty that sort of get out of responsibility free card. So.
Yeah, I think I would kind of look back on just, kind of some basic principles of like, what is the product? Will you sell the same product to different people, or does whether or not you sell it change on who the person is? And also, is who that person is a protected class under the law in the jurisdiction that you're in? So if this individual, had said that he was going to this rally because he believed in white nationalism, and you're, you're looking at, is that protected class? Can I deny this, selling it to this person because is he a member of a class that is protected under this law? I mean, there might be other reasons that you would have to sell him the car under other consumer laws, but under this particular one, he would be a protected class. So I would kind of keep looking back at that. And some of the things that you mentioned before were things that were kind of also looked at by the court in the case that was in the 60s, and it was like I said, someone who made barbecue, and he makes custom barbecue products for weddings. And I actually was reading the brief that was written by the NAACP in support of the couple that sought the cake in this case. And they were citing to numerous places where barbecue was referred to as an art, and that this individual was known as an artist of barbecue in what he did. And so if we're going to look at that, then you could maybe say, but this was what was looked at in the court then, and kind of already decided that he still needed to provide this to different customers, regardless of their race. And even though his religious view was that he didn't want to encourage the intermixing of races, that wasn't enough to overcome the state's legitimate interest in ensuring equal access.
Can I ask a question about that case?
So.
Can I ask a question? So was it that he didn't want to sell barbecue at all to African Americans, or he didn't want to sell it to them for a particular event?
I think in that case it was that he didn't want to sell it to them at all.
So that would be distinct then from Jack Phillips, who does welcome gay and lesbian customers.
Well, I think the distinction would be that he does offer wedding cakes to everyone, but wouldn't offer a wedding cake to a couple that wanted it. So.
Steve, thank you for the presentations. I find it fascinating. One of the things that strikes me looking at the bigger picture, in my lifetime, one of the great changes socially has been perspectives on sexual identity, gender identity, and the acceptance of different forms of gendered relationships. This has happened socially, and it's interesting to think of what the relationship is between that and the courts and the law. Mm-hmm. If we have something like the Constitution, which is setting out general principles, and at the same time, there appears to be a sort of change over time to the ways that the courts are generally reflecting upon this and addressing it. Is this a process whereby you're taking key concepts that are already in existence, some of the ones that you've mentioned, and you're just sort of expanding the definition? Or is this a reworking of the principles? Do the principles stay the same in the applications? The categories become expanded or contracted? Or what enables this sort of change within the legal system over time?
So I think part of what you're asking about here is when we have groups that get designated as needing or deserving special protection, and there's a long history of that. Actually comes from a footnote, a very famous footnote that talks about discrete and insert minorities who may not be able to have their day in the legislatures. Legislatures are designed to defend what the majority wants. That's why Catholics and Episcopalians didn't have to worry about getting wine from communion during Prohibition, because they could get it. Whereas Native Americans did have to be available to the courts when it came to peyote and Jehovah's Witnesses. So you look at our famous, religious exercises. There are almost always a religious minority that the majority thinks is rather odd. If they were a majority, they could protect themselves. So when it comes to equal protection, these different categories, the Supreme Court has, there's been this process of evolution. There's at what point, what triggers our most exacting scrutiny, right? There's these different levels of scrutiny. Race, gender, I think, is intermediate scrutiny. So it's been kind of a hodgepodge process where the Supreme Court has addressed it, but it's not that you've had these great legal minds that have sat down for 3 weeks just to figure it out, right? It's been a back and forth sort of confusing process. And that's why the issues today, whether it's sexual identity, transgender, or gender identity, are those sorts of identities exactly like race? Or sex, or the different, or like religion and sexual identity. Sometimes people seem like there's some volition involved, other people not at all, right? So that's a long way of saying it's a very messy sort of thing, and I think it's still in process.
Yeah, it is a very messy sort of thing, and one thing I thought was interesting was that the NAACP, for instance, doesn't think that these things should be treated differently. Undoubtedly, race and sexual orientation are different things and have different histories, but in the way that they have been treated by society as a whole has been similar, and the language that has been used against these minorities has been similar. And so a lot of times the courts and legislatures are really slow to catch up with society and changing understanding of humans and human condition and things like that. One thing I object to that you said was that people found for special protection, and the idea of these laws is it's not special protection for these classes, it's equal protection that's otherwise been denied to these classes. So
The scrutiny would be
Yeah.
high. Yeah, and I mean, so you see here one of the disagreements that we have, right? So the NAACP is an important voice, but then African Americans generally have about 60%, as of 2017, don't necessarily approve of same-sex marriage. So we have a difference in terms of how closely we see the race analogy. I see some closeness, but actually see them quite different. Whereas I think you see them very much as analogous. So that's part of figuring out what we think about this, right? To what extent is the gay and lesbian American experience analogous to the racial experience in the United States, and to what extent is it different? Jack Phillips lived out basically the position that Barack Obama ran on in 2008. So it's fascinating that 10 years later, then Mac go out of business for that view. So this is where these things get dicey.
I had an interesting experience while I was here at Oglethorpe. I actually got to hear Coretta Scott King speak here while she was still alive. And she often spoke in favor of this idea that sexual orientation should be treated in a similar way that race had been within the law, even though the characteristics are different. That the treatment, the ability to access equal treatment needed to be the same. And I also have got to speak with John Lewis while I was living here, which was also very exciting. And I thought it was very interesting that of Dr. King's children, I think one of them very strongly believes that her father did not intend to support gay and lesbian people with the work that he was doing. And she is a minister at a church here. And so that is something that she talks about often. And I really wanted to ask John Lewis, what exactly does this do within the King family to have, his wife and his children, for the most part, agree with this concept that sexual orientation should be, gay and lesbian people should be treated equally. What has happened within the family that you have one that so differently says this is an insult to her father and his work, And he just shook his head and he said, you can teach your children right, but you can't control what they do.
Religious freedom is often talked about in terms of people that hold sincere religious beliefs. Do you think that protection should extend to people such as atheists that hold sincere beliefs against religion, that they are sincere non-believers, because they should have the same protection as those people who hold sincere religious beliefs?
Yes, I do think so. I think that similarly, if we looked at a reverse situation where you had, if you had an atheist baker who did not want to make religious cakes for weddings, that would be a situation where they didn't want to make cakes for religious weddings. They would still have to make a wedding cake for a couple that was, having a religious wedding. You couldn't say, I only make cakes for people that are having secular ceremonies and not religious ceremonies.
So I would say yes, but I'd say the exact opposite, that the atheist should be able to say, no, I don't want to participate in your religious ceremony. So we both are consistent in one stage, just going the complete other way.
Yes. I really enjoyed the argument of the differentiation between what is being served and who is being served. Mm-hmm. And Dr. Michael, I wanted to see if in this situation you viewed it as a differentiation between serving a gay couple and serving a gay cake, in a sense.
It's certainly, the impact of it is going to be felt by the gay couple. There's no doubting that that would be a hard thing. I guess Phillips sees it as not participating in a ceremony that he finds problematic, but he still serves gay people, right? So in that sense, it's not an animus towards people. Now, it's also the case that most of the people that he would refuse to serve by participating in their weddings are going to be same-sex people. The mother came later and tried to order the cake, and he said no. So she wasn't gay, but she was acting as a proxy, I think, for the gay couple. When the other bakery folks refused to bake the cakes with the religious messages, the Colorado Commission said, well, they're not refusing because these people are conservative Christians. They're refusing because of the message, right? And that's what Kennedy and Gorsuch actually about. You need to have go the same way on both cases. So if the progressive bakeries can say no because of the message, not because the person's a Christian, right? Then why can't the conservative baker say no to the message, not the orientation? I guess that's what's at cross purposes here.
I think a really key difference there is that the people that wanted the anti-gay messages wanted a literal message written in words on the cake, something that is very clearly speech. It contains letters and words. So they were asking for a message that was put on there. And not only that, it would be a message that would be hostile to a protected class in Colorado, which would be gay and lesbian people. And so in the case of the couple, they didn't get to the point of what kind of cake they wanted, and wedding cakes don't usually have words on them, so it's harder to look at it as any particular message involved. So I think those are distinguishable.
So this raises a good diagnostic question. The new cake that Jack Phillips and Joel were refusing to bake was celebrating a trans woman's change, and it was meant to be blue on the inside and pink on the outside. The whole point is to celebrate the shift. So would you agree that there's clearly a message? That would you say you would be justified in not participating in expressing that message?
Sure. I think if a person called and said that they wanted a cake that was blue on the outside and pink on the inside, that he would have to make that cake. And the cake is the same whether a person just wants a cake that's pink on the inside and blue on the outside, or if the person is transgender and wants it to represent their gender transition. Like, the cake is the same thing.
So he's not participating in the expression of a view.
No, I don't think so. He's making the same cake, but denying it to one person based on what, because they are a transgender person, and it represents that person.
So one of these helpful is you're seeing us disagree agreeably on these things, right? Hopefully, right? So that's actually just laying out the different sides of this, which, frankly, given our political climate, even if we're not on the same page in all these areas, I think a very, very good thing.
It's time for one more question. Anyone have a question? Well, not. Thank you so much.
I have one more thought. Oh, sorry. I was just going to say,
By all means.
I had notes and there was something I didn't say. One of the things I encountered over and over online when I was arguing with strangers on the internet, because that's a really smart use of your time, is the people that just said, well, why didn't they go to a different bakery? Why would I want a homophobic person to bake my cake anyway? Like, why didn't I just go somewhere else? And this is the same thing as asking why the black people just didn't go to a different restaurant where people, might have been willing to serve them. And when you look at it in that context, to us today, the harm is evident to the people involved. And I don't think that those things should be, as we've already discussed, kind of treated differently. And so when I came up against those arguments, that's what I continually thought of. So that's how the context I think those should be seen.
Thank you.